And contrary to what you might suppose if you never studied the rules of evidence, what you tell the police, even if it's exculpatory, cannot be used to help you at trial, because it's what we call hearsay. Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, "Officer, would you tell the jury what my client told you, because what my client told him is actually good for my case? If you tried that at trial, the prosecutor will object that it's hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help." And that ought to be good enough reason. That ought to be reason enough to keep your mouth shut. But if you're not persuaded, let me go talk about a couple of others. Number two, obviously one of the most obvious. If your client is guilty, as many of them are, but even if he's not, even if he's innocent, he may well admit his guilt with no benefit in return. Now, of course, many of you are thinking to yourself, well, what's so wrong about that? I mean, shouldn't guilty people be confessing? Confession's good for the soul. It's good for law enforcement. It's good for the prisons. Yes, sure, all those things are true. And like the rest of you, if I or anyone close to me is ever the victim of some sort of a serious crime, I hope they get the right guy. I hope they convict him. I hope they put him away. We all feel that way. Hey, but what's the rush, friends? You don't got to admit your guilt the first time they come by to meet with you. In federal court, 86% of all defendants plead guilty at some point before trial. If your client is guilty and really ought to punish and really ought to have go through some sort of a cleansing act of contrition and fess up and admit his guilt, there'll be plenty of time to do that. They almost always do. No need to rush, no need to tell the police something. Wait and see if perhaps your client can work out some sort of an arrangement where maybe he'll make some sort of compensation to the alleged victim, or maybe he'll be able to get some sort of a discount in his sentence. And he'll be treated fairly then, like everybody else who had the benefit of a good lawyer who said, please do not talk to the police. And don't forget, by the way, even if your client only admits to things that the police already knew, you might think, well, what harm can it do? He says he wants to talk to the police. All he wants to do is admit that he was there, but the cops know that he was there. All right, go ahead and tell him. Well, how can it hurt? It might hurt if the police officer becomes transferred to Minnesota, or deceased, or injured, or comatose, or cannot be located by the time of trial. The case will be dismissed if there's no confession. But if your client admits to things, that confession is freely admissible against him and can be a basis for getting him convicted all by himself. Senator Larry Craig can explain all of this to you.